Hi everyone, welcome back to Emphasis Added. I'm one of your Season 7 hosts, Tiari Vincent.
And I'm your other Season 7 host, Tammy Bengali. Today we have the honor of speaking with Professor Laura Portuondo. Professor Portuondo is a constitutional law scholar with expertise on reproductive rights and justice, gender equality, and the First Amendment. Professor Portuondo joined the University of Houston Law Center in 2023 and teaches constitutional law, family law, and reproductive rights and justice reform. Professor Portuondo, thank you for joining us today.
Hi, great to be here.
Perfect. So we always like to start out by discussing our guest's background and allowing our audience to become better acquainted with them. So can you just tell us a little bit about yourself?
Sure. So you guys did a great job introducing me. I'm an assistant professor here at the Law Center. I teach common law, family law, reproductive rights, and justice. Before becoming a law professor, I did sort of various post-law school things, like I clerked for some federal courts. I did a public interest fellowship at the Center for Reproductive Rights, and I was also a clinical teaching fellow at Yale Law School's Reproductive Rights and Justice Clinic. So that sort of covers my areas of interest.
That's lovely. What led you to want to practice or teach law? Is that something you always wanted to do?
Yeah, I wasn't really sure leaving law school exactly what I wanted to do. Teaching was something I was always sort of interested in, but I really knew coming out of law school I wanted to do something in the area of reproductive rights. It was an area that this was pre-Dobbs, so I could sort of see the future coming, that Roe was really in danger, Casey was in danger. It was an area I cared a lot about, so I thought, let me go try to practice in this area. I did the public interest fellowship. I had the clerkships lined up, and after my second clerkship, I was thinking, or I guess during, trying to figure out what I wanted to do next. And the judge I worked for actually really encouraged me to go into law teaching, but I still wasn't totally sure. So I took the clinical fellowship, which is kind of like halfway between being a real lawyer and being a professor, to kind of have a foot in both worlds. And then I said I really liked teaching students. I really wanted to do the scholarship, and so I just went for it. And it worked out.
Very cool, yeah. So you've had a pretty unique career path. You mentioned you started as a clerk and then you did the clinical fellowship and now you're our professor. So we want to ask a little bit about your experience as a clerk. So can you tell us about how that was?
Yeah, so clerking was really great. I clerked first on the Southern District of New York, which is a district court. So that's trial court judge. And that was like a really jam-packed experience. The judge I worked for, Judge Rakoff, is known for taking any trials that any other judge doesn't want or doesn't have time for. So we were constantly in trial, which was actually really cool. A lot of federal clerks don't even get a trial experience because so many cases just settle before trial. So it was very high speed. I loved my district court clerkship. In a lot of ways, you're kind of doing what you would be doing at the appellate court, but you're just doing it more and faster. So I kind of liked that. And also during that clerkship, that judge sat by designation on the Ninth Circuit. So that meant I was doing sort of half an appellate clerkship at the same time I was doing a district court clerkship. So it was totally crazy, but it was really cool. The judge was great, really nice, gave us a lot of autonomy. So that was awesome. And then I also did an appellate court clerkship on the Second Circuit, which was also great. It's a little slower pace. Like I said, I kind of like the district court better, which really surprised me because I didn't even want a district court clerkship. I just kind of randomly ended up with one. So yeah, it was a great experience.
Wow, that sounds so exciting. I can't imagine that right after law school. That sounds so exciting. You've talked a bit about your clinical fellowship experience, what influenced you to do that. So how was the pivot, the transition to teaching from clerkship and from the clinical fellowship experience? How was that pivot? Were there any challenges pivoting to teaching?
Yeah, I mean, I think I think clinical professors have a really tough job because you're practicing law, right? But you want to give students the opportunity to sort of do the majority of the work. So I think there's special challenges with giving the right amount of freedom and discretion to students, but also kind of supervising and making sure students aren't committing malpractice, for example, because that's your job, right, is to supervise. So that's a really interesting challenge, I think, is balancing those two things, which is very different from doctrinal teaching, where it's more I'm sort of lecturing or sort of giving you information and then you spit it back to me right in an exam or something like that.
Cool. Yeah, very cool. Thank you for providing us with that background for you. And so we'd really like to dive into the heart of today's conversation, which is constitutional law topics at issue today. So we want to start with reproductive rights and justice. We know that's your area of expertise, and you've written a lot on this topic. So can you kind of explain to our audience what reproductive rights and justice means?
Yes, so reproductive rights and reproductive justice are actually two different things. So reproductive rights might be something you're more familiar with. Think like Roe versus Wade and Planned Parenthood versus Casey. Those were Supreme Court opinions or legal protections that said, right, there's a right to abortion, there's a right to contraception. So when you're advocating for reproductive rights, you're kind of going to courts, you're trying to get those specific kinds of rights protected. But as you may have learned in common law, maybe not, these rights are somewhat limited. Right? You say you have a right not to have an undue burden on your right to abortion, right? Even when that existed, that was interpreted to say, well, let's say someone's really poor and they're on Medicaid. Do they have a right to funding to get an abortion? The answer under a reproductive rights framework is no. So that actually meant a lot of poor women were not even able to get abortions or really meaningfully exercise reproductive choice, even with the protections of Roe versus Wade or Planned Parenthood versus Casey. So thus came in this reproductive justice movement, which was led by a coalition of women of color that were interested in advocating for a broader understanding of kind of this right. So, right, they don't want just rights, they want justice. And so the tenets of reproductive justice is the right to have children, the right to not have children, and to raise those children you have in safe communities. So it's taking a much broader lens, and it's more political advocacy, saying everyone has a right to make important decisions about like their families, the resources they need to have the families they want. So right, it's not just about not having kids, it's a right about to have kids, right? To have kids, to have those kids in safe communities, a much broader conception of that right. And sometimes the reproductive rights movement and the reproductive justice movement are in tension.
That's a good definition. That's a good definition. So on land with that, should reproductive rights be viewed primarily as a privacy issue or an equality issue or both?
Yeah, so I think it's like a combination. I think sometimes it's tempting to say, oh, it should have been this, it should have been that. My view is it wouldn't really, from a practical perspective, it wouldn't have mattered under whether it was protected from privacy or equality, whether the right was eliminated or not in a lot of ways. But I think if I want to like theoretically think about the right as I would best frame it, I think it's basically at the intersection of liberty and equality, right? So you might say, right, it's really important for people to be able to have like reproductive choice, right? That's a liberty framing, but you want to make sure everyone has that right equally, right? That's kind of what the reproductive justice movement says is like, we all agree this is, well, I guess not everyone agrees, right? But people who are in the movement, right, we can all agree that this is an important thing for people to have, but we all want to make sure everyone experiences it equally. Because a problem with, let's say you just say, oh, it's only an equality problem. Well, if it's only an equality problem, you could say, well, nobody has any reproductive choice, right? Everyone would be treated equally. So that wouldn't be enough, right? You need both the liberty to say what are the things that are important and the equality to make sure those things are distributed evenly along lines of, right, race, gender, class, all these different things.
Very cool. Do you think the framers intended that interpretation of the Constitution, that it would protect decisions about bodily autonomy, or do you feel like that's more of a modern interpretation?
Yeah, I mean, it kind of depends on how you look at it, right? So when you're thinking about what did the framers intend, did they intend for there to be like a right to abortion specifically? Probably not, right? They probably weren't thinking about that. Did they want there to be a right to like bodily integrity? Probably, right? So it depends on whether you think the idea of bodily integrity includes something like the right to abortion, right? So it kind of depends. We talked about this in constitutional law at the level of generality that you're looking at the right that you're talking about. So if you look at a high level of generality, you say, right, we're protecting important, intimate decisions. Probably the founders did have some idea of like a conception of privacy, right? But if you go down more specifically and you say, well, did they want X, Y, or Z practice? Maybe not so much. So it kind of depends on your theory of interpreting the Constitution. To my view, right, it doesn't make a lot of sense to just think about, well, what did these few people who were empowered at the time think about specifically, precisely what people's rights would be? Because if you think about it, at that time, there were many, many people who were disenfranchised, right? They didn't have a right to vote or contribute to those conversations. That includes enslaved people, that includes women, it includes a lot of people. So to my view, it makes sense to kind of update the Constitution to match a more changing, empowered voting demographic.
That's great. So, like, how is the Supreme Court's decision in Dobbs v. Jackson reshaped the constitutional conversation about reproductive rights?
I mean, I think it's interesting. I don't think it's changed the scholarly conversation that much, right? There have always been people who have thought that the right to abortion should be protected by the Constitution. There's specific theories of that. There's always been people who've said it shouldn't be protected, and there's theories that support that. So in a lot of ways, like, it didn't change that conversation. It just said, well, in this instance, like, the side that said there's no right kind of won and prevailed in that opinion. But I think it has changed the constitutional conversation more broadly. I think that a lot of people are it's raised the salience of the issue of abortion and reproductive rights and justice, I think. I think a lot more people are more passionate about the issue than they used to be. I think people's awareness is more raised. And interestingly, I think it's pushed a lot of blue states, for example, to become much more protective of abortion, for example, and saying we want to be able to ensure that people can get care here, that our doctors are safe, all that, which has actually led in even red states to an increase in the number of abortions that are happening because there's so much more access, there's so much more awareness and salience. So, right, the Supreme Court has made a constitutional decision, but in a lot of ways, people on the ground have responded to that and kind of pushed back. So I think it has changed the conversation if you're looking at the scope of constitutional actors, including the public more broadly.
Interesting. So you mentioned that it's changed the salience of this issue. So kind of along those lines, what unresolved questions did the Dobbs decision leave open for future litigation?
Yeah, I mean, one really big one is what is there some constitutional minimum of protections for unborn life, for example, right? So in Dobbs, Supreme Court said, we're not adopting any particular theory of life. We're just saying, right, the state can do it. The state can say we want to protect potential life, and therefore we're going to ban abortion, right? So they said we're not deciding this issue. At the same time, the opinion used a lot of language that suggested that at least some justices on the court were really interested in this idea of protecting prenatal life as the same as, right, born human beings, right? And so I think that's sort of the next frontier of constitutional litigation on this issue is, are there protections in the Constitution for potential life? If that's true, that would potentially require restricting reproductive rights, not just in states that want to do it, right? Texas is already doing that. In, let's say, New York, right? They have really strong protections for reproductive freedom. Might those be restricted, according to the Supreme Court, by the Constitution? So I think that's one open and really important question.
Yeah, that's a great segue to our next question as well, about how might the constitutional reasoning in, for say, Dobbs influence current issues like contraceptions, IVF, and same-sex marriage?
Yeah, I mean, so this is another sort of open question in that opinion. So again, that opinion said we're not touching the right to contraception. We're not touching the right to same-sex marriage, the right to same-sex intimacy, all these things, right? They're like, no, this is just about abortion. Abortion is different. It's special because it involves the killing of, right, prenatal life. So, right, you might be comforted by that. At the same time, the reasoning that the opinion used totally undermined, right? If you take it on its face, totally undermined all of those cases. That's because abortion, right, while the court might be saying it's different for X, Y, and Z reason, the jurisprudence, right, the line of cases leading up to Roe versus Wade and Casey, it's all of these cases, right? They're all intertwined. They're all going on this same idea, sort of calling back earlier to our conversation, that rights should evolve, right? We shouldn't think about rights at a really specific level of generality, saying, oh, the right to abortion, right? Did the founders want to protect that? We should be thinking about a right to privacy and what kinds of broad things fall under that umbrella. So Dobbs said we want to look at the most specific level of generality. If you're at that level of generality, that eliminates potentially a whole range of rights, right? Because do you think the founders thought about and were saying we want to protect a right to same-sex intimacy? Probably not, right? Were they interested in protecting sort of like marriage and marital freedom and, sexual freedom more broadly? Like, probably. So the reasoning in Dobbs really potentially undermines all of those opinions. I think it's a question of, ultimately, does the court feel it has the political backing to go back on and claw back those opinions? I don't think it's really a question of law. I think it's a question of like how constrained the court feels by politics, basically.
Yeah, that's like interesting last thing you said, because I'd seen like somewhere that they're like, oh, you think like the executive has the most power? It's actually the judicial system, because pretty much they're the ones who are saying what goes and what doesn't go now, like with Casey and contraception. Like just the reasoning sometimes that the court uses.
Mm-hmm.
Yeah.
I agree. Yeah, thank you. This has all been very informative and very helpful.
Yeah.
I don't think we mentioned Professor Portuondo was both of our constitutional law professors and also both of our family law professors.
Sure.
And my family law, her family law is in a couple days. So I should be taking notes. But thank you again. So you mentioned that the Supreme Court's ruling in Dobbs kind of gave a lot of that power back to the states on how they want to regulate reproductive rights. So can you address some of the tension between the state's interest in potential life and individual constitutional liberties, or is there a clear line that has been drawn?
Yeah, I mean, so if you think about state interests and liberties, they're sometimes on the opposite side of the equation, right? So you say an individual has a right, and the state can restrict that in the name of important interests, right? So these things are often sort of in opposition. Somebody might say, right, I have a right to again, easy here would be right to abortion would be on one side and the right of prenatal life on the other side, right? And so I think that, right, they are often treated as in tension in the jurisprudence, but we also know that sometimes, right, thinking about this interest in protecting prenatal life, there's a lot of ways that the state could do that, right? The state could, for example, give better funding to pregnant people who are poor, right? Say, we're going to support your prenatal care. We're going to support, let's say, a midwife, which leads to better health outcomes. And those kinds of things are going to actually lead to better health outcomes for both babies and for their mothers, right? Or let's say we're going to support a right to more robust health care for children who are here, right? Make sure they're healthy. We're going to support their schooling. We're going to do all these things in ways that are going to improve health outcomes for children. Often states we see Texas do this. Often they're interested in protecting prenatal life in ways that restrict people's autonomy, right? We say we're going to ban abortion, we're going to do this, right? We're going to limit people's choices. And then they turn around and they don't engage in the policies that would be more supportive, right? That would be equally effective, if not more effective, at protecting life, but that would actually help and support people's choices. So I think often there's this idea of there's this tension between these rights, but in a lot of ways, if you look more broadly, there's a lot of different ways to support people and protect life. And so there doesn't have to be this tension. And the state could adopt policies that would be more broadly supportive of people. So I think there can be the tension for sure, but I think if you think more broadly, there are ways to kind of support both women, pregnant people, and children at the same time.
That's cool. So going on the line on what like states may do for to protect potential lives, what constitutional issues may arise if states try to criminalize or criminalize people who aid or provide abortions, like doctors and all those people?
Yeah, so I mean, I think a lot of what's going on right now is because doctors in Texas are not going to provide these abortions if they're subject to criminal penalties. They're not doing it. The people who are doing it are people who are out of state, right? So there are physicians who Texas right now is trying to criminalize who are sending abortion pills into Texas for people to take. So a lot of this is like interstate conflicts issues. New York and other states have passed laws saying you can't prosecute our doctors. Texas is saying, yes, we can, right? So this will eventually come to courts to figure out, like, how do we figure out these interstate conflicts? I will also say one reason for that is that a lot of states don't actually criminalize having an abortion yourself. So if you decide to have an abortion, the law doesn't apply, doesn't criminalize you. So this could, right, if ultimately states are not effective at stopping doctors in other states from delivering pills, which is just a really easy way to get an abortion, basically, states might turn more to criminalizing pregnant people themselves. And I will say states have already done this, again, even before Dobbs. They have arrested, jailed, prosecuted people for example, smoking marijuana while they're pregnant, saying you're harming the fetus, right? Again, this is another situation where you say, well, there's a conflict between the mother and the baby, but actually when you criminalize pregnancy in this way, what happens is it leads women to hide, right? They don't get medical care. They want to make sure nobody can find them, right? If they're, let's say, struggling with addiction, they want to make sure the state can't find them. And so that actually leads to worse outcomes for babies. So again, right, criminalizing the conduct of pregnant people is not really a great way to pursue this policy of protecting potential life, but nevertheless, it's ones that states adopt anyway.
Interesting. You mentioned this interstate conflict and how people might turn to the courts to get some of this resolved. But in your opinion, could they turn to Congress and the legislature for them to constitutionally pass a nationwide abortion ban or protection?
I mean, absent a right to abortion, I don't see why Congress couldn't pass a law banning abortion. In the same way, I don't think there's a reason that Congress couldn't pass a law protecting abortion, right? I mean, as you learned in constitutional law, right, Congress has all these various powers under the Commerce Clause, right? It's having this effect on interstate commerce. I think quite clearly abortion or a lack thereof is having this interstate effect. That said, if Congress passed a law protecting abortion rights, I think there's a pretty decent chance that the Supreme Court would try to find a way to strike that down as beyond Congress's power.
Yeah.
So, like, in my opinion, Congress absolutely should be able to pass a law, just like it absolutely should be able to pass a law banning, right? Under Congress's powers, I think there should be a right on the other side to protect people. But just on the question of Congress's powers, this seems well within Congress's authority to me.
Yeah, that's interesting. So we're going to pivot to a next constitutional issue that Professor Portuondo is very familiar with, which is reconciling the tension between the First Amendment and the 14th Amendment. So the First Amendment guarantees freedom of speech and religion, while the 14th Amendment guarantees equal protection and due process. While the two can work together to protect individual rights, there could be tensions between them. Where would you say the tensions between free speech and equal protection principles show up most clearly?
Yeah, so my writing is about not just speech, but also religion. So I think about these sort of conscience claims, whether they're coming up under the speech clause or the free exercise clause. I think we see these issues coming up most frequently with things like a public accommodations law, right? Anti-discrimination law that says if you're a business, you have to have your door open to all comers. That includes people who might be LGBTQ, for example. And so we've seen a number of cases come up to the Supreme Court where someone says, I'm religious, I own this business, I run it in accordance with my religious practices, or I'm speaking in my business, right? I'm making wedding websites, for example, and it violates my beliefs, it violates my speech rights to make me serve these customers. And so there you see the tension between, on the one hand, the conscience right and the equality right of an LGBTQ person. And I think also women, sometimes it runs up in that direction as well.
Oh, yeah, there's a case about that, right? The woman who didn't want to, marry or create a website.
Yes, that's
I remember,
303 Creative.
Yes. So you mentioned that courts are starting to see these situations where that tension comes up. So how have they handled the situations? And then, in your opinion, are they doing it right, or how should they handle it?
Yes. So the way that courts handle this is, and this is just fresh from the press is my opinion, the way that they tend to handle this is they're often very solicitous of the First Amendment right. They say, right, someone's being compelled to speak, someone's religious freedom or religious exercise is implicated, which I don't think that's necessarily incorrect. So courts are willing to see and recognize the First Amendment interest, and then they completely ignore the equality interest on the other side, right? So they say, well, this equality, right, this is just a statute that's protecting people's equality. It's not a constitutional interest, right? So you say, basically, there's the First Amendment interest on one side and then just a vague statutory right to equality on the other side. Of course, the Constitution is going to prevail over that. So I think what courts tend to do is they resolve what is really a conflict of rights by pretending that only one set of rights is at stake. So in my view, the better way to resolve these conflicts would be to recognize that the conflicts exist, to say, right, yes, there's a speech right on this side, or there's a religious liberty right on this side, but there's also an equally important equality right on the other side, and we need to basically balance and figure out the right least restrictive solution to this. And so as I'm saying that, you might be thinking, well, are courts really well equipped to do this, balancing, making policy judgments about whose rights should prevail over others, which is why ultimately I think more of these decisions should actually be shifted to democratic branches. Which often, if you look at these public accommodations laws, they do have some provisions, some exceptions for First Amendment rights. So I think in a lot of ways, we're getting a less nuanced system by constitutionalizing these and recognizing only the First Amendment rights.
So, at this age of technology, a lot of social media, Twitter, is there a way the government can regulate speech in order to prevent discriminatory harms without violating the First Amendment?
Yeah, I mean, that is a whole can of worms. That also gets into, who's a government actor, right? Is Twitter some sort of quasi-government actor? Is Facebook some kind of quasi-government actor? And these are huge questions. I think right now, the general idea has been more towards deference towards these platforms, with increasingly people are starting to challenge and say, well, we should be regulating these platforms more strictly. And I think it's just an unsettled area that we're going to have to see where it goes.
Interesting, yeah. It's ever evolving. And then I think you'd consider who owns some of these social media sites nowadays. Yeah. And they could be maybe a quasi-government actor.
I think we did one essay in LSS about acting under the color of the state, and if someone acting under the color of the state posts something on Facebook, is there another kind of homes opening, that kind of situation?
Really interesting.
Yeah.
So you mentioned some of the constitutional battles between the First and 14th Amendments that have already reached the court, including religion, in some cases involving women. So what are some battles that you think are likely to reach the Supreme Court in the next decade or so?
Yeah, so I think that there's going to be more of these anti-discrimination law versus religion kind of things coming up. For example, there's I think one frontier on this is charter schools and school funding. So for a very long time, under the Establishment Clause, there's the idea that you can restrict funding to religious institutions, right? You shouldn't be funding religious schools, for example. But this is principles basically totally disappeared in favor of actually a lot of times you have to fund religious institutions. There's this case called Carson versus Macon where the Supreme Court said if you're giving generally available education funds to private charter schools, you have to give them to, or secular private schools, you have to give them to religious ones, right? Like a Catholic one, for example. And so that's established law. The next question is some of these states have said, well, okay, you can have the money, but only if you comply with the anti-discrimination law. right? Any school can get this funds so long as they don't discriminate against LGBTQ people. Schools have started challenging these and saying this is a discriminatory funding provision. We can't comply with this because it violates our religious beliefs. So the next phase, I think, is saying, can the state condition funding on compliance with the anti-discrimination law, or are religious institutions entitled to that funding without any strings attached, basically? So this could lead to, right, schools, that state-funded schools that discriminate on protected characteristics, foster care agencies, healthcare institutions, hospitals, right? Any kind of public-private partnership could have this effect.
Wow, I feel common law is such an interesting area of law, ever changing. Wow, that's interesting. So it's widely known that political protests or protests in general are a way that citizens use to show their disapproval of a government policy or action. And it's also known that in this administration, recent times, law enforcement has been called to respond to these protests. There's been some in New York, LA, Los Angeles with ICE and all of that. What constitutional issues arise when law enforcement responds to protests, especially civil rights protests?
I mean, so people have a right to protest, right? That's a very long and storied history. I think sometimes the way that the government frames this intervention is by saying, well, we're just trying to prevent violence, right? You don't have a right to commit violence, for example. That said, I think a lot of times it's going to depend on how much deference is a court going to give to, say, an executive, whether that's a federal or state executive, saying, well, there's this danger, right? That's why we had to stop people from protesting, right? Do we really believe that that danger is there? Or do we think, right, it's sort of a pretense to shut down dissent? And so I think we definitely see a lot of heavy-handed interventions into protests right now that I think, are incompatible with the First Amendment principles that are really foundational to this country, and this idea that people have a right to protest, they have a right to dissent, and they shouldn't be subject to state violence for that.
Mm-hmm. So kind of along those lines, would you say that certain communities experience violations of First Amendment rights differently because of 14th Amendment equal protection issues?
Yeah, I mean, I think to the extent that certain groups expressing particular political views, right, content-based discrimination, are we saying certain kinds of protests are policed more than other kinds of protests, right? That would be a content-based violation, content-based discrimination, which could be a violation just under First Amendment principles by themselves, right? But if you think about the ways in which, right, if we want to do an equal liberty analysis, right, are some people more affected by this police than others? Sure, right? It depends on the kinds of resources that people have. Can they have access to lawyers? Are they sort of well-resourced and able to push back against these kinds of things? You see with obviously we see with some of the targeting of particular immigrant communities by ICE or something like that, right? There's a disproportionate impact of those things on Latina communities, right? So I think there's all these different kinds of impacts that you can see across different, right, racial class groups, for sure.
Wow, that's interesting. This has been such an amazing conversation about reproductive rights and justice, about First Amendment and 14th Amendment. Thank you so much, Professor Portuondo, for joining us today. It's been an honor, truly.
Thank you.
You're welcome.
So before we close, is there anything else you'd like to share with our audience? Any advice for students, final reflections, or any predictions for the future?
No predictions for the future, but I'll wish everyone good luck on finals. Know that your grades don't define you, and also your first job after law school doesn't define you. You're gonna do well.
Great advice.
Great advice. Thank you. We need that because it's starting next week. And thank you to our listeners for tuning in to Emphasis Added. Make sure to follow us on your favorite podcast platform. Thank you.
Perfect.
Great.
Thank you. That was really nice.
That was really nice and
Very
like
informative.
thought-provoking, actually. I hope we chose like good topics.
Yeah, you guys did a good job.
Yeah.
You guys did a good job.
Yeah, I hope we really get the immigration people to come. We've been trying for like a year.
Yeah.
To get them, but they've been busy with the
I'm
clinics,
sure.
so,
Yeah. I mean, that stuff's going crazy right
like,
now.
that would be like a perfect part 2 to this.
And plenty of time too. You guys were right. It does go fast.
Yeah, it does go fast.
Yeah.
I think we skipped like 1 or 2 questions, not too